The justices are wrestling with a question about whether states can count ballots received after Election Day in a case that could have an impact in nearly 30 states that allow some kind of grace period. The RNC is challenging a Mississippi law that allows ballots to be counted up to 5 business days after Election Day if they're postmarked by Election Day. Justice Alito was among the biggest skeptics during Monday's arguments.
Independence Day, birthday, and Election Day, and they're all particular days. So if we start with that, if I have nothing more to look at than the phrase Election Day, I think this is the day in which everything is going to take place.
But Justice Kagan questioned the impact of that logic on practices like early voting.
It seems to me it's a rule that prevents early voting, because you're basically saying there are two things that have to happen, and they have to happen on Election Day.
Meaning the casting of the vote and the receipt of that vote. But attorney Paul Clement, representing the RNC, said the argument is that the process be consummated or completed by Election Day. A number of the justices also raised the issue of the potential for the appearance of fraud when votes arrive and are counted after Election Day. And there wind up being shifts in vote totals and how that may impact public confidence.
So, ladies and gentlemen, in today's video, let's get into this because the Supreme Court may be getting ready to drop a hammer on one of the biggest election issues in this country. And if this goes the way that it looks like it might, this could be a real problem for the Democrats. Because what the Supreme Court is looking at here is simple. If a mail-in ballot shows up after Election Day, should it still be counted, even if it's postmarked on Election Day? That's the fight right now. And from the tone of the arguments, it sounds like the courts may be leaning towards a much stricter standard, where sure, there will be ample time provided to vote leading up to Election Day, but once the day passes, it's done. Not, we'll keep counting and see what's coming in later. No. And so the RNC is backing this challenge, arguing that once you start counting ballots that show up after Election Day, you create uncertainty and open the door to a process a lot of Americans already do not trust. And so we're going to break it all down. As always, if you enjoy the content, smash that thumbs up button. That's the best way to let me know. To make sure you stay locked in with future videos, subscribe to the channel and make sure you hit all for your notifications. That way YouTube never forgets to let you know when I drop. Let's get into it.
You have 8 states that don't even require a postmark. And there is nothing in Mississippi's theory that turns on the existence or the non-existence of a postmark. And that's probably a good thing because the Post Service has made clear that they don't even postmark all of the mail. And postmarks have their own problems. I mean, the main mailbox, the post box in, post office rather, in Chicago stays open 24/7. So when all the other polls close in Illinois or every other state at 8 p.m., the post office is still open till midnight. Now, I'm not here to say that there could ever be voting fraud in Chicago, but the possibility that there's a 4-hour window where people could go get their ballots, absentee ballots postmarked after all of the returns are in, and they know that, oh, this is the election where these things could turn the result, that does not seem entirely
So is your argument that
we have lots of phrases that involve 2 words, the second of which is day. Labor Day, Memorial Day, George Washington's birthday, Independence Day, birthday, and Election Day. And they're all particular days. So if we start with that, if I have nothing more to look at than the phrase Election Day, I think this is the day in which everything is going to take place. Or almost everything. And then we have 3 points in time, 1844, 1872, 1914. And we can ask, what would people have thought on those days is meant by this phrase, Election Day? Which of those should we choose? Which of those dates should we choose?
Well, I think you could choose any of the three. I mean, honestly, I think the single best one, if you're just going to choose one, is 1872. And the reason I say that is because 1914 is the latest in time, but that's the one that Congress gave the least thought to.
You believe that absentee voting by the military and overseas voters, the various laws, that federal laws under which states have proceeded with respect to those votes are illegal?
No, I don't.
Or they're not saying what everybody has understood them to say, that states can accept absentee ballots after the election?
So
military and overseas ballots?
I don't think any vote is unlawful. Let me try to address how I think you would reconcile UACAVA with the Election Day statutes. And to start, I think it's important to recognize that UACAVA is not limited to the federal general election. So UACAVA applies to primary elections, to runoff elections, and special elections, and federal general elections. The Election Day statutes only apply to the general federal election. So the way I would reconcile the two is to say that all the references in UACAVA to state deadlines are perfectly fine, not preempted at all, not displaced at all, not even anomalous. With respect to the primaries, the runoffs, and the special elections. Then the court has a job to do in the federal general election as to say, like, kind of which is the specific, which is the general. I think the more logical way to do it would be to say that with the understanding in this court, if you decide in our favor, that for the federal general election, the ballots have to be in by Election Day, I would say—
Maybe we should have another president now, because wasn't it in Florida that they were counting military votes after receipt?
So with all due respect, that is the reddest of red herrings, because what happened in the 2000 election in Florida is that pursuant to a consent decree that was entered by a federal court, because Florida was violating the principal provision of UACAVA, which says you have to give the absentee ballots to the overseas voters 45 days in advance. Because Florida was violating that, there had to be a consent decree to create a remedy that was not provided
What happened was that the judge made up the deadline, not the state.
And so basically, they want to cut down on the situation where votes are still being counted, like in some cases weeks later, and make election day cutoff, where if you cannot do what you need to do, even though you've been given ample time with early voting leading up to it, that's on you, in my opinion. They're not even saying that they're removing mail-in voting completely, just that if it comes down to the last minute and you're getting your ballot to the post office in a situation where the post office may be still open, but the polls have already closed, then that does not count. And it looks like that's where the Supreme Court is leaning right now. But let's go ahead and jump into this next clip where they discuss who gets to set the determination on this. Is it up to the state, or has Congress set the rule on this when it comes to election day ballots? Take a listen.
The arguments themselves, what was your takeaway from them?
Well, I was really struck by how much the arguments focused on the issue of whether or not it was a good idea that about a third of the states had decided to allow for ballots that were voted on or before Election Day to come in a few days later. There's a disagreement amongst the states on here for very valid reasons. There are variables, for instance, how reliable the mail is, how far voters might have to go to deliver a mail ballot in person at the last minute. Those are all things that could be considered. And those 14 states vary greatly in terms of political leanings. It goes from the red state of Mississippi to the blue state of California. And the justices seem really concerned with whether this is a good idea, and they pose several, frankly, rather unlikely hypotheticals around this situation. But what this case was supposed to be about at its core is who gets to make that determination. Do the states get to make that determination, or has Congress already set a rule on this and said all ballots have to be in by Election Day? And on that issue, there really isn't much doubt. Even Congress doesn't believe it has set that rule yet. They continue to try to pass legislation that would do that. The White House doesn't think Congress has set that rule yet because the White House included that in their executive order from about a year ago. So it was unusual that we saw the justices focus so much on these kind of unusual hypotheticals. I'm not so sure about the tea leaves here. I think there were a few justices that were still trying to figure this out and determine whether or not the Constitution and or Congress has expressly stated that mail ballots that were voted on or before Election Day have to be in by the close of polls on Election Day. I think most of us who've been following this for some time know that that's in our history not been the case, and Congress has not set a clear rule on that.
Listen, I think there are solutions to this issue that can make sure everyone who wants to vote still gets to vote. That's number one. Whether you're talking about the military, where maybe it needs to be stressed that these are hard deadlines. I don't think that's too extreme to solve. Our troops are already accustomed to deadlines and time management because of the nature of the military. But when you look at citizens, considering how long election season actually is, it really comes down to being more responsible. I mean, that's the reality of the situation that maybe people do not want to actually say out loud. And here's the thing: prioritizing getting it done and not waiting until the last minute. Because if it's that important, if we're saying voting is that important, why are you waiting until the last moment? Why not show up at the polls? And if you are going to mail it in, then couldn't that have been completed weeks, days ago, giving yourself enough time to make sure you're not in that situation? It's like when you were in school, college, the professor gives you a project, gives the whole class a project due on a certain date, and he says it needs to be turned in by the beginning of class, no later. Email it, do whatever you got to do. You can turn it in early, you can make sure it's submitted before class starts. But what always happens? What always happens is you got students begging for extensions, asking if they can turn it in by midnight because they didn't prioritize it. No, you can't. And so, yeah, I believe there are solutions to make the current system safer, more secure, and build more trust in the election process. But let's go ahead and jump into the next clip with Assistant Attorney General of the DOJ chiming in. Take a listen.
Is it legal for states to continue to allow ballots to trickle in after the official federal election day in November and count them? Or is that inconsistent with our federal election statutes? That's the question that the United States Supreme Court confronted today in a very interesting, more than 2 hours oral argument that I had the privilege of witnessing. We at the Civil Rights Division, where we're charged with enforcing our federal election laws, had the privilege of co-authoring a brief with our Solicitor General, who then argued it in court today, together with two of the other top oral advocates in the country, including former Solicitor General Paul Clement, who argued for the Republican National Committee to uphold the lower court ruling from the Fifth Circuit that indeed the practice of Mississippi, and by the way, parenthetically, many other states, of allowing ballots to trickle in and be counted days and sometimes even up to 3 weeks after an election is inconsistent with our federal election statute. So, in prior cases, the United States Supreme Court has addressed these types of issues, and Justice Kavanaugh wrote in a case in 2020 that these kinds of disparate trickling in and uncertainty and a wide swath of different kinds of laws creates uncertainty around elections and indeed undermines confidence in our elections. So we argued in our brief that because Congress has these laws that refer to an election day should mean election day, meaning the last day by which ballots can be received by the state and processed. And so here, Mississippi allows it for 5 days. Some states allow it for 10 days, up to 21 days. 8 states don't even require a postmark on mail ballots. So for those of you who are concerned about whether this would impact our military abroad being able to cast their ballots, it doesn't, because there's a special statute for that under federal law, so there's no preemption issue. And so here I saw a very spirited argument. All of the 9 justices asked questions. I think there was a distinct trend in how some of these justices were viewing this. And this isn't Mississippi's first trip to the Supreme Court. There was a case called Foster versus Love in 1997, where it was kind of looking at the opposite end of the spectrum. Mississippi had an open primary law that said that at the primary level, if any particular candidate, even a federal election, got a majority of the votes, that was the end. There was no need for a general election. And the Supreme Court held that this violated the very statutes that we're looking at here about a federal general election day. And so it's going to be interesting to see the court reconcile that prior decision, some other decisions by the court, and look at the legislative history. And so I'm really excited to see this case come out. And if it comes out the way that the United States is arguing at the Civil Rights Division and Solicitor General's office, i.e., that it is inconsistent with federal law for states to continue to process and accept these ballots after the election day being the first Tuesday after the first Monday in November, set by federal law way back in the mid 1800s. I think that's actually going to be a positive development for voter confidence in the outcome of our elections, regardless of your party, because we're going to know that final means final, and there aren't some shenanigans with a bunch of people, your neighbor or whoever, delivering a dump of ballots into the mail after the election day. So stay tuned for further developments in this case.
I think overall, this is a good thing. If the Supreme Court leans toward closing this loophole because mail-in ballots already leave themselves open to fraud due to the fact that they are not cast in person and due to not having strict voter ID laws backing those ballots, you can potentially have thousands of fraudulent ballots being cast by individuals, taking advantage of the system. Solving issues like this that offer more trust, more security, and ensure that our elections are fair and not fraudulent is a win in my book. But that's my thoughts and the update. Now I want to hear from you. Drop your comments down below. As always, smash that thumbs up button. That's the best way to let me know you enjoy the content. For more, subscribe to the channel. And as always, until next time.